So welcome, folks. Good morning. This is the SSI, SSDI training with our wonderful colleagues from the Benefits Law Center. My name is Jody. I use she, her pronouns. I'm from the Seattle-King County Coalition on Homelessness. Tim, if you'd like to just do a brief introduction of yourself so folks know who you are.
Sure. My name is Tim. I use he, him pronouns, and my title is Member Connector with the Coalition on Homelessness.
Wonderful. Thank you. Before we hand it over to our colleagues, I want to just take a couple minutes, just welcome folks in. We love seeing faces on camera. You're able to change your name so we can see names, pronouns, agencies. If that is not where you're at this morning, we at the Coalition fully understand. So if you're here to just get some really solid, wonderful information to help you do your work and help the folks you're working with get the benefits that they need, we're good with that. If you do not want to be included in the recording today, just stay off mute, throw your questions into the chat. Tim and I will be helping to monitor that. Our colleagues have set up a structure of their agenda where they'll go over a section, leave time for questions, move on to the next section. So I don't think we'll lose anything in the chat there. It's possible if we have a lot of questions around a particular subject. Okay, sorry about that, folks. If we start to run out of time or there's a lot of questions around a particular subject, just to make sure we can get through all of the key pertinent information, we might ask you to just be sure to throw that into the chat and we'll catch that stuff up on the back end. One thing I did want to just share with you all is we at the Coalition do a lot of work around policy and advocacy. Public benefits is one of the huge things that we do and one of the huge ways with which we support people experiencing homelessness, disability, unstably housed, and the way we support providers. Another way that we support providers is through our campaign called Essential Work, Essential Workers. And this work is really to help uplift the incredible work you all do. Call it out as such, which is why we called it Essential Work, Essential Workers, right? You all showed up every day, 24/7, some of you, through a pandemic when everybody else went home. And we want to highlight the fact that you are all in that same realm as police and fire and first responders and medical providers in terms of the safety and the health that you help provide folks and our neighbors in King County. We want to highlight that to lawmakers. And when we do that advocacy, we tend to win because as a coalition, we're really strong together. So this past budget season at the City of Seattle and at the King County budgets, we were able to get inflation adjustments for service providers. And we want to bring you into that work and make sure you are aware of all of the meetings and trainings and good action alerts that are coming out of it. So Tim's going to throw some links in to the chat. One is around homeless service provider stipends. So if you haven't heard of this, ping one of us offline will get you more information, but and how to sign up for that. But we want to know how that's going for folks. We want you signed up for our emails because I know Benefits Law Center did an amazing job of promoting this, and we have a huge amount of folks that are registered for this and currently here. So if you heard about it through Benefits Law, we also have other public benefits trainings and meetings for folks. So sign up for our emails. We have a training page as well. And then finally, we have a post survey. Public benefits is a huge part of our work and understanding who's doing this work. What are the system issues that they're facing? What kind of trainings do they need? What kind of support? So the post survey is a really helpful way for us to keep refining our work and keep bringing you what you need. So that was my little preamble. Now I'm really, really excited. We've got Benefits Law Center, several colleagues here. Benefits Law Center provides accessible legal advocacy to folks living with physical and mental disabilities so that they can obtain necessary resources to overcome barriers to financial and medical stability. And they really further their mission to target advocacy projects that help people with Social Security disability problems. I'm going to pre-apologize if I mispronounce any of your names, and I invite you to do a little intro into your own section, but we have Alex Strout, who is a paralegal. We have Hui Nguyen, who is the executive director, Hillary Lovell, director, attorney of Disabled Homeless Advocacy Project, Tanner Yamada, an attorney, and Peter Greiser, Director of Legal Services. Thank you so much for being here. And I'm going to turn it over to you all and let us know how we can support. Thank you.
Thank you, Jody. I appreciate that. Thank you to the coalition for hosting us this morning and putting together this great training event and ability to share what we do here. My name is Alex Strout. I'm a paralegal here at Benefits Law Center. So I'm just going to take you through with my co-lead, Hui Nguyen, the executive director here at Benefits Law Center, take you through the first part of our little training and then kick it off to our colleagues as we go. Hui, do you have anything to add so far?
No, thank you, everyone. My name is Hui Nguyen. I'm the executive director of Benefits Law Center. Again, thank you so much for being here today. We're hoping to share our experiences and information and knowledge so that you can do the best to help people out in your community. And like was said before, we are very appreciative of the fact that you're frontline workers, essential workers, much like healthcare workers or police officers. We think that's really important in terms of the work that you provide. Alex is going to go ahead and start it off, and he's going to share screen in terms of the PowerPoint presentation. We'll get it kicked off.
Alrighty, let me just get it started. Yeah, and Hui, if you don't mind just looking at the chat as we go, but because I cannot see, I can only see what we're presenting, and so we'll go from there. But again, yeah, my name is Alex, and this is Hui. We are presenting sort of the basics of navigating Social Security and how we interact with our clients and with the community and what we do, what our advocacy looks like. So just to go a brief overview of what we're doing. So this is just for Hui and I, the first 30 minutes or so. We'll have questions at the end. So if you have any questions as we go, just we'll have some time set aside for that. So we're going to talk a lot about what SSA is, Social Security Administration, what it's like during COVID, what are the Social Security benefits that are available, all of them fully, and then what are the ones that we work on here at Benefits Law Center, what advocates can do, that's both you all and then also what we do here at Benefits Law Center, what attorneys do when they take on clients and cases, and then how we can support you going forward as we do. Once we're done here, we will kick it to a colleague, Tanner and Hillary, who will talk specifically about doing applications for Social Security benefits, SSI, SSDI. And then the last 30 minutes or so will be with Peter Greiser, and he will be talking about overpayments. And so we're going to go through all of these, but the goal for Hui and I is just to give you some context and baseline of what Social Security is, and then we'll let our colleagues, the attorneys here, go kind of just much deeper into that part. So just to start, so the Social Security Administration was started and signed by FDR in 1935. It was just the Social Security Act. So it created the benefit structure that exists to today and the retirement programs that exist as well. It was renamed in the 40s. And then in the 50s, because the first act excluded many different workforces, including agricultural workers, domestic workers. These were very racialized, so it took about 15 years for them to sort of include almost all kinds of workers in the US. And so that was in the 50s when that became a part of the Social Security Administration. In 1995, it was deemed its independent agency, which just meant that it was an administrative arm that, as we see it now, the Social Security Administration, as separate from the other parts of the government, but in particular, that's when it became its own agency that we work with, as you see now. So currently, it's up to 60,000 employees. There's 10 regional offices, including one here in Seattle. And there's 1,200 or so field offices, including 5 here in King County. So there's one in Bellevue, there's one in North Seattle on Aurora, there's one downtown at the Federal Building, and then one in Burien and one in Kent. So basically, as what we're here to talk about, it's the most effective anti-poverty program that is out there, has massive clear inequities, which we will go through, and how they work with people that are disabled, work with people that are low income, work with people that are homeless. But it is one of the strongest programs out there in order to get benefits, a monthly benefit for people who need it. We're going to go through that as we talk. So what does SSA do? Social Security is the federal government's financial safety net. It provides disability benefits, retirement benefits, survivors benefits, and it executes these all in very different ways. And so again, we'll go through all of that. But they also administer Social Security numbers, Social Security cards. They run all of that, and then also collect retirement benefits and whatnot, and keep that for people as you work and move through your life. So specifically talking about Social Security during COVID, all of the field offices closed down, of course, right when COVID happened. They did not reopen until April of 2022, so they've not even been open for a full year yet. Most of the workers worked from home, but they are now back in their offices, and the spaces are open, which has been as having about 2 years of not being able to go into an office, and for somebody who doesn't have an access to phone or whatnot, was very difficult. So much better now that the offices are open, but the wait times are extremely long still. It's just really, just know that if you go there, it's a couple of 2-3 hour wait to see somebody and get some either turn documents in. And this is really important in particular because, sometimes you need to show IDs or passports or citizenship situations. Having to, prior to April of 2022, having to mail those in was a hassle and possibly really dangerous for clients and community. Now, at least you can bring those in, but it is going to take a long time to go through that process. The hearings office, which we'll talk about the difference between working with the local field office and working with the hearings office. But the hearings office is where, if clients have gone through enough appeals, they'll go to the hearings office, and they're in front of a judge. They're scheduling those now by telephone or Teams, or if you wait and want to appear in person, which some of our clients do, and some people that's preferable for them, there is a long wait time for those to be scheduled, but they are scheduling hearings in person again. And lastly, Social Security is relying heavily on their website to process appeals. Again, they're sort of pushing people towards the website, although, access for the clients that we work with and the community at large is not always available for that. So.
Great, thank you. And so I'm going to be talking about the different types of Social Security benefits that a person could apply through the Social Security Administration. There's 2 basic types of benefits that a person could apply for. The one is based on non-disability benefits, and the other is based on disability. Work history is something that is considered in regards to your application, and will make a difference in regards to how much you get, and also which rules and regulations apply to you that will either maintain your benefits or terminate your benefits. And so it's important to know the differences. Many times our clients, when we talk to our clients, they don't know which type of benefit they're getting. They know they're getting something from Social Security. And so there are tips and tricks that we can give you today to try to identify which rules you might be under, because that can make a difference in regards to whether or not that person maintains their benefits. Also, some of the Social Security benefits comes as a package of other types of benefits, such as Medicaid. So that's something that's really important to understand, that if there's a disruption in your SSI, your client's SSI benefit, that may mean there are maybe other disruptions or other things that you'll have to do to help them maintain their other benefits, much like with Medicaid. In terms of non-disability benefits here, and we'll definitely try to get our PowerPoint slides to Jody and Tim so that they can share it with everybody. So that way you can refer to it. But if you are, the information that we're going to give right now is very cursory. So if you are confused or trying to get more information about which specific type of benefit your client is receiving, the Social Security website does have fact sheets on these different types of benefits. They're written in very layperson terms where it's easy to understand. I think the trickier part is trying to find those fact sheets, which can be somewhat convoluted or hidden. A Google search will not bring them up immediately. So it is a matter of having to do it a little bit of digging. But if you need any help with identifying or finding the information, just let us know as social workers or as a community member, and we can try to get you hooked up with the right fact sheet. Because many times the rules are very complicated and complex. And even for paralegals, advocates, and attorneys, we have to look it up. We have to look it up ourselves because the rules change or the rules accommodate whatever year or go up every year. And so the benefits go up every year. So that's something that we do have to keep updated on because the rules are very malleable and can change very quickly. First type of non-disability benefit is the one that we would commonly associate Social Security with, is Social Security retirement. This is based on your work history, and this is also based on when you were born, when retirement goes into effect. So we know that if you take early retirement at age 62, you're going to be getting much less in Social Security benefits if you take retirement at age 67. And that effective date for retirement, again, is dependent upon the year that you were born. So if you were born at a later or earlier year, you may be eligible much earlier. Old age supplemental security income. So this is based on not disability benefit or disability status, but on your age and also your financial requirements. So this is commonly known as SSI. So again, this is based on if you're over the age of 65 and if your income and resources are low enough to qualify for the SSI benefit. Anytime resources or income is taken into account, and if you're found to be low income or have few resources, different sets of rules kick in. So that's just something very important to understand about Social Security, which is for SSI, that means there are much more restrictive rules that may apply to your client in terms of what they can have in terms of income or in terms of resources. So anytime you hear Social Security, be on the lookout to whether or not they are receiving supplemental security income, because there are additional rules which we'll go over really quickly today. And Peter will also address the issue of overpayments, terminations, and things like that result as a result of if they find or allege that there's a violation of those income and resource rules. Spousal benefits is another type of non-disability benefits. This is retirement benefits on your spouse's records. If you're over age 62 and your spouse is receiving benefits, you can receive up to half of your spouse's benefit amounts. And then there's survivor benefits to family members of a deceased person who is qualified for benefits. Again, this is very brief. There's additional information in regards to this, but we're just going to touch base really quickly. And Alex, if you can go to the next slide, please. So here we see the different types of disability benefits. And like I mentioned before, supplemental security income SSI, this is for people who meet the income and resource limits and medical eligibility requirements. And so that means they have no work history. This could be someone who has a developmental disability or a chronic type of condition where they aren't able to work on an ongoing basis and don't have that work history available to them. They're going to be receiving a fixed amount. In 2023, if for one individual who on SSI, it's a fixed amount of $914, which is actually an increase over the years, which it used to be much lower. It does increase every year, but if you hear the term $914 or the number $914, that should be a red flag immediately that your client is receiving SSI. That's a fixed amount. For a couple, it is $1,371, so $1,371. Again, if you're working with a couple or client and you hear that number, that is a very clear indication that your client receives SSI. And that's where we need to be really careful about income and resources, much more so than someone who will receive retirement or disability. The next one is the one that we would know for someone who has a disability or is able to qualify as having a disability, a Social Security disability insurance. It's for people who have earned enough work credits and meet medical eligibility requirements. So work history is required here. So Social Security used to do this, but I don't think they do it anymore. But back in the day, in the early aughts, I would get something from Social Security that said, if I were to be disabled, based on my work history, I would get XYZ amount. And I believe at one point it was like $1,500 per month. So as you can hear, that's much different from someone who's receiving the fixed amount. And the reason why it varies is because that is based on my work history. That also means that anyone could get Social Security disability. So Bill Gates or Jeff Bezos, even though they have multi-mansions, if they were to become disabled at any point in time and apply, they can receive their share of Social Security disability because that goes into their work history. So that's just something to keep in mind, that that's based on work history, and it can vary. So if you hear someone who receives Social Security disability that's different from 914 or 1371, that is a clear indicator that that's not SSI. And then there's a disabled adult child benefits. And so these are for adult children who became disabled before 22 years old and have a parent who is receiving retirement or disability benefits. Next slide, please. I see that we have a question, but we're going to wait till we're finished, and we'll definitely get back to your question once we're done with our section, which I think is coming up pretty quickly in terms of time. So just in some differences in terms of who qualifies for SSI and SSDI. Under the right-hand column for SSI, we can see here your age 65 older, or you have what's defined as a disability. Resources for SSI, you can only have $2,000 in resources. So that means what a resource is something that you can convert into cash in the fair market for fair market value. All right, so if you go on Craigslist and sell something, that is something that can be considered a resource. It could be a car, it could be a checking account or savings account. All those types of things can be a resource. And so that's a really big issue for a lot of our clients, because if they have a checking account and money is being put in there without them knowing, if they go over that $2,000 resource limit, they are looking at being terminated or losing their SSI. Now, let's say someone puts in money into their account without knowing, and they have $2,000 and $2,001. Let's say they're $1 over the resource limit. What happens is that if Social Security discovers that, and let's say it's been there for a year, that dollar, the extra dollar has been there for a year, not only is that person looking at being terminated, but they have an overpayment of a year because of that $1, right? So that is can be a huge amount. So if in some cases we have clients with overpayments of anywhere between 30 to 50. In my other practice, we had one with $100,000 overpayment. And that's something that is really scary for many of our clients. And it has a really huge impact in terms of their economic security, which Peter will talk about. You have to have limited income. We'll talk about SGA, substantial gainful activity limit, in a minute in terms of what you can work. There are some sort of immigration status requirements. That's its own. I believe that that section is its own 2 hours, or at least an hour and a half. So we won't cover it. But Washington Law Help has some really good information about what a person can apply for and qualify for if they don't have U.S. citizenship. And then to the right here, we see SSDI. To my right, this person meets Social Security definitions of disability. They have sufficient work credits. So those are credits that you have to earn to be eligible. And then certain types of age requirements that you have to meet in order to meet SSDI requirements. And I will turn it back over to Alex to see just common problems. And some of this I may have talked about really quickly before.
Yeah, so we break our Social Security problems into two different categories, and that is an eligibility or what we call an entitlement case. And so this is someone who is trying to get onto benefits or needs to appeal a denial of being awarded benefits. They haven't received benefits, and they're trying to start that process. So that's an entitlement case or eligibility case. We have specific attorneys here that work on those cases. and then specific attorneys that work on what we call post-entitlement cases, which are cases for somebody who has been receiving benefits, and then all of a sudden, as we mentioned, they get an overpayment for a resource issue or for working, or because they have a continuing disability review, which is a process that happens every few years for all of our clients that are on disability-based benefits, that they review their disability and then determine whether they're still disabled or not. And so if you are terminated from that after a continuing disability review, those are also post-entitlement cases. So we break those up into those. It's just important to know that's kind of how we discuss them, but those are the two kinds of problems that we deal with and see a lot of. So this is just going to, again, because Peter is going to be talking later in this training, I am going to let him do all of the specifics of this, but just getting some definitions out here. So an overpayment is when Social Security says that the client owes Social Security money back for benefits that they received. Usually this is sort of something that happens after the problem has been realized, and then it goes back a certain amount of months or years. Termination or cessation of benefits is because maybe Social Security realized you're over the resource limit, or that you started working and didn't report that, or a variety of things. They can't get in touch with you. They'll do that sometimes for termination and cessations as well. So again, so that's a problem that our clients run into. And then a continuing disability review, which I talked about as already. And so Peter will go into all of these more, and I will allow him to do that kind of towards the end of the training. So here is talking about eligibility or entitlement cases. And so this is a graphic that was produced by Social Security themselves in 2019. But you can see, so there's different levels of an application and how many applications Social Security allows. You can see on the left side there, 37%, deny 63%. And so these are each different stages of the process of trying to get onto benefits. And so you can see when you apply, and then when you have a first appeal, and then you have a hearing level with a judge, and then there's an appeals council level after that, and then it goes to federal court after that. But you can see how an attorney sort of affects those processes, and how I think one of the misnomers of Social Security is they will deny you immediately on the first time, and it will take a long process of many appeals in order to get your benefits. And while that is true for some of our clients is are accepted on just the application level and whatnot. And so this is kind of to sort of dispel that myth that you have to get denied a few times before you are approved of benefits, but it also shows you how long the process can take going through all of these different forms. So the definition here on the left is the definition of disability according to Social Security. So inability to engage in any substantial gainful activity because of medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months, and results in not being able to perform past work or any work in the national economy. And so these are the underlined and bolded parts are the really parts that are become the big contention points in an application, and that our attorneys work on with our clients. And so you can see that these are kind of the important parts of that definition. And Hillary and Tanner will later we'll go more into this definition and kind of flesh that out. But that's the definition of Social Security. Basically, you cannot, your medically determined physically or mentally impairment means that you cannot work for or pass any work that is available in the national economy. So and I'll let them kind of go through that more, but so that's the legal definition, of course, although, it's a very narrow definition and difficult definition. It's even narrower than the ABD or HIN vouchers that happen, those definitions of disability.
Great. So I'm going to talk a little bit about the services that Benefits Law Center provides. So why does Benefit Law Center exist? Because we do know that if you are applying for a Social Security disability determination and you're denied, that wait can be up to 2 to 3 years to get your hearing. So it can be a very long and arduous wait. In many of those cases, if they prevail upon appeal, what happens is that they are awarded retroactive benefits. That means while you're waiting for your appeal, you get nothing. You get nothing from Social Security. And if you're disabled or if you have a lot of barriers, that means that you can experience a lot of instability and hardship, such as homelessness, while you're waiting 2 to 3 years to have your claim adjudicated. In many of those cases, because there's retroactive benefits, that is something that an attorney can be referred to and get those retroactive benefits, a percentage of those back benefits, so that way the attorney can get paid. So that's one reason or one really great way to get access to legal services. However, if there's a private attorneys, why does BLC exist? The reason why BLC exists is twofold. The first part is we really believe in centering our clients, being connected to community partners, and showing up to where our clients are. In many cases, many of our clients have many barriers that they're experiencing, such as homelessness, mental health, substance addiction issues. And for many of the attorneys, the private attorneys that work on these cases, they're unable to manage these barriers or work with the client or connect or build rapport with the client. And so some cases, the private attorneys will refer those clients to us because we center our clients and we really value access, client access, to be able so that they can be able to get their benefits and be able to communicate and connect with them in ways that other organizations cannot. Second of all, there are very few other legal aid organizations that do Social Security. So if some of you are familiar with Northwest Justice Project, which is the largest legal aid organization, their legal services corporation, in Seattle or Washington. They serve hundreds and hundreds of low-income clients in civil legal aid. However, they do a very small percentage of Social Security cases. So we're basically the main game in town in regards to these types of issues and questions. And the second reason why we exist is because of post-eligibility cases. So a lot of people think, okay, I qualify for disability, it's done. I don't have to worry about it anymore. That's not the case. As you've heard already, there are many problems that a person can experience through Social Security Administration, which is very ironic that a government agency that is designed to work with the elderly and disabled is the least accommodating to these individuals. There's so many barriers that they experience in terms of accessing benefits. Many times as an attorney, I remember waiting 2 to 3 hours for a scheduled appointment at Social Security, and there's no chairs. I had to sit on the floor with my clients, right? So that's something, there's a lot more to it than that, but that's just an example of how that the agency treats or devalues individuals who are elderly or are experiencing disabilities. And so for many of the cases that we work on, for post-eligibility, that means if they're being cut off. Currently, there are about 36,000 people on SSI in King County. That means any one of those individuals at any given time can be cut off. In worst case scenario, have an overpayment, or even worse case scenario, they'd be looking at fraud, right? Criminal fraud if they said you did it on purpose. And so those types of cases have no attorney fees, and that's one of the second reason why we exist, which is to work with those cases, which can be in the hundreds of cases and clients experiencing hardship. And if you think about it, if someone is on disability, they're in public housing and they get cut off, that's the beginning of the end. That's a downward spiral for many individuals, where if they can't pay their subsidized housing or if they don't report their income, they get evicted, and then that means they're now homeless, right? Or the other side, the flip side, which is if they're homeless, trying to get to a doctor but can't for whatever reason, because of their barriers, and they can't get on Social Security disability, and they're on the streets for up to 10 years. That's a really important aspect or service that we provide. So we do take a lot of different levels of services. So we provide advice, counsel, brief services where we only handle a portion of the case, and then full representation. The other types of services you can see below here, which are aspects of a case that we can help out on. We're also available for consultation. So if you're working with a client and you have a question, that's something we can definitely try to answer your questions. We are a very small and scrappy crew. There are 10 of us total and 5 attorneys and 2 paralegals, but we really try to honor our commitments with our community partners and try to be there to answer your questions. And under BLC, we have two programs, the Social Security Advocacy Project and the Disabled Homeless Advocacy Project, which are based on eligibility. And the other one is based on meeting people out where they're at community partner outreach sites, and also working with post-eligibility cases. Again, private attorneys will not take those post-eligibility cases, which are just as dire or as important as an eligibility case. Next slide, please. We're going to go through this really quick because I see we're going over time, and I don't want Tanner and Hillary and Peter to be shorted their time. And so we're going to try to wrap this up really quick. We're almost done, but here are some barriers to Social Security benefits. And many of you, if you're social workers, you're very familiar with these barriers. Again, homelessness or houselessness, or living outside, not having a permanent address or a way to communicate is a really big barrier, especially with a lot of the mail that comes from Social Security. And the mail is pretty wild at Social Security. It's almost like a circus where they can give you forms that say, please respond on December 24th, and it's a Sunday or something, right? And there's no way to respond because everything's closed. So that's something that I think is a really big aspect of a barrier. Many of our clients have mental health, physical impairments. Transportation is a really big one. Even though there are field offices throughout King County, many of the offices are out there, or if they're sent to a medical evaluation that is very far away because the medical contractor is very far away. That's a huge barrier that we've been experiencing recently, and we're trying to troubleshoot. Access to technology, of course, such as phones or computers, limited English proficiency. So right now, Social Security is not translating their notices with exception for Spanish. We're on it, we're looking into it, but that's a huge barrier, especially if they're told to respond by a certain deadline and they can't read the notice because it's in English. That's a big problem. And as lawyers and paralegals and advocates, we're looking at this to see what can be done in regards to the lack of translated notices. And then, of course, social support, such as family. And then next slide, please. Alex, did you want to talk about some of these?
Yeah, so just a little bit about what we do. I'll give you the overview of our thing and the briefest possible. But yeah, so we try to build relationships with each of our clients. We know that the cases are going to take many years sometimes. And so we know it's going to be a relationship building process so that we can keep in touch with our clients, make sure that they are getting some of their needs met while this process is happening. And also so because they're going to tell us a lot about their life in terms of disability and their situation. And so we want our clients to be able to trust us in this process as we go. We do community outreach locations is another one to really highlight here. Each of our attorneys has an outreach location that they go to on site. Some of them have multiple ones. Most of them actually have multiple ones where we meet with the clients in the buildings where they're at, Chief Seattle Club, DSC, Mary's Place, King County Veterans Program, Open Doors. Those are all places where we meet our clients in location so that it will make it easier access for them, and also so that we can get things done much faster than having them come to the office or do it on the phone. And then we have interpretive services. So if that's ever a question, we have those services available.
Yeah, and one quick thing, we have the Justice Bus, which is currently not running too well right now because it's really old. It's almost got 400,000 miles on it. So we're hoping to find a solution for the Justice Bus, but it's a really good way for us to get out into the community, to get to where the people are. And we hope to in the future to get to either get a new Justice Bus and have a scheduled time when we're out at Social Security offices or at CSO offices throughout King County. And I think the last slide we've already kind of talked about in terms of what we do. Let's try to answer some questions in the chat and try not to short shrift the other advocates. So Hannah put in our Instagram. Our email is here. Alex and my email are here. So if you have questions, if you don't get it today, then you feel free to email us and we'll try to get back to you.
Yeah,
Okay.
Feel free to email me and call the main line whenever. Myself and my colleague Maria, we cover all of any new contact information, send us questions. We are always more than willing to answer any questions, even if we may not have an advocate available to help, or we may not have an attorney that can look at the case. We're always willing to give as much information as possible, get any questions answered. So feel free to send them our way.
Yeah, so first question is, are you interested in becoming an outreach partner? Yes, we are very interested in becoming an outreach partner. And that is something that we're hoping to develop. We do want to prioritize and emphasize diverse partnerships, right? So that means if you're serving diverse populations with a race, equity, inclusion perspective in mind or lens in mind. And we are actually mapping that internally to see who we're serving or not serving to make sure that we are equitably providing services to all our partnerships. But yes, Compass Center, love Compass Center. I used to hang out there as an attorney with my clients. So definitely just feel free to hit us up, either me, Alex, or any of the other attorneys, and we can get that started. Anything you want to say about partnerships, Alex?
No.
Next question is, why is the denial percentage so high for the first 3 times you apply?
Yeah, I mean, I would say that I think the definition, and Hillary and Tanner may talk more about this specifically, but the definition of disability is really stringent. It's really hard to get that, and they require lots of medical evidence. And of course, not everybody can get that, to Social Security. There's lots of reasons why it is, but yeah, I think the definition is a really difficult definition, especially when they say a lot of times clients are disabled, and Social Security will say, but you can work in the national economy doing this job. And so it becomes, I think it's a difficult thing to do, and why why we exist, and why having somebody help our clients through the process is really important.
Yeah. The other thing is, many of those people that apply don't have attorneys. So they don't know the language, the magic words that need to be spoken, or the secret password that needs to be spoken, because sometimes it feels like that in terms of just legal mystique, right? So that is something that later on down the road, if they do get access to an attorney, that's something that the attorney can help provide additional information for eligibility. Something to know is that in administrative hearings or appeals for Social Security, you do not have right to counsel. So they will not get you an attorney. And even if you have mental health, cognitive disabilities, they will still expect you to proceed without an attorney if you can't find one. So again, there are attorneys that will take eligibility cases, private attorneys. Sometimes they will dump or ghost on their clients, right? Which is unethical, but it happens. And so that's something that's to be aware of. Even though they might have a private attorney, there are complications and barriers. How much do your services cost? Alex, did you want to take that?
Sure, yeah. So we don't charge for our attorney's time. Again, we mentioned if there's cases with back pay, usually eligibility cases getting onto benefits, we take 25% of those, or $7,200, whichever number is lower. And so, yeah, that's the only time that we take we take 25% of the back pay. But other than that, we don't charge. We're do legal aid services.
And I want to make sure that we have time for Tanner and Hillary for their section. So this will be the last question. If you didn't get your question answered, we'll try to email us, and we'll try to make sure to respond. Yeah. And so the last question is, BOC serve only King County? Is there similar nonprofit in Snohomish County? Yes. So we only have the capacity. Like I said, we're very scrappy but committed and passionate about the work that we do. But there's only a certain number of us to be able to handle all of King County. Right now, like I said, about 36,000 people receive SSI in King County, and of the problems that can arise, that's a lot of problems, right? Or a lot of legal issues. And a lot of people don't know about the resource limits and things like that. So we're trying to do as much outreach as we can, but currently our funding only allows us to serve King County. Is there something similar in Snohomish? Northwest Justice Project does have an office, a field office in Snohomish County. You could do some outreach there, or call the CLEAR hotline. That's the Coordinated Legal Education Advice and Referral line through Northwest Justice Project, if you're familiar with it. And that's something that you could try to see if you can get a referral to. But if you can't, because of capacity, there is Snohomish County Legal Services, which could try to get you to a pro bono attorney if possible. Although it is, like I said, a smaller county with a smaller pool. So that's something that could be not eligible. Your client might not be available to get a pro assistance, right? Again, we're open to answering questions if they're in different counties. In some cases, what we're trying to do with additional funding is to reach out to the tribes, right, to indigenous tribes in those areas and Snohomish and Pierce. But currently our funding really restricts us to King County. And with that, I'm going to hand it over. I know there's more questions, and I know there's a lot more coming in, but I do want to make sure that Tanner and Hillary have enough time to present, and I'll pass it off to them.
All right, thanks, thanks, Alex. I'm going to share my screen really quickly. Let's see here. And is everyone seeing that okay? I can't hear.
Looks good.
Great. Let me just try to.
Yes.
From beginning. Oops. You guys still seeing that okay? Does it look normal?
We can see it, but we can see your pre-slides too. Yeah.
There we go. Okay.
There you go. You're set.
Hey everybody, my name's Tanner. Thanks so much for being here. It's really cool to see 150 people in the audience. A little scary, but also very, very cool. So thanks everyone for being here. My name's Tanner. I'm an attorney at Benefits Law Center. Me and my colleague Hillary, we're going to talk to you guys a little bit about applications. Definitely, this isn't going to be a complete overview of the entire thing, but hopefully this gives you some info and maybe some ways to move forward and assist some clients. There we go. So again, something to just reiterate is that there's two different types of Social Security programs that provide disability benefits. One is SSI, the other is SSDI. I think for the purposes of today's meeting, the most important thing to think about in terms of difference is that SSI has financial requirements in terms of the resource limit, and then SSDI really depends on whether or not the individual applying has worked enough and paid enough into the Social Security system to be eligible for SSDI. I work with a lot of folks who just unfortunately aren't eligible for SSDI due to their work history. Thankfully, SSI is still an option at that point. So again, we already looked at this chart a little bit. We can breeze by it, but again, SSI, you need to have resources less than $2,000. There's some exclusions that I know that Peter is going to talk a little bit about in his presentation. Also limited income, the claimant has to earn less than $1,470 in gross income a month for this year. That number changes every year. Like we mentioned, yet for non-citizens, that is its own presentation. It gets really tricky, but if you guys ever have a claimant who's wondering if they're eligible because of their citizenship, definitely reach out. I particularly like looking into that issue. And then, yeah, SSDI, like I said, it has to depend on your work history. Younger people are required to have less work credits, obviously, because they had less opportunity to work, but there still is a number that younger people have to earn before they're eligible. The general rule of thumb is that if you're 31 years or older, you have to have 10 years of full-time work, and 5 of those must have been in the last 10 years before you apply for disability benefits. And so here's another thing to talk about. It's a little pessimistic, but I think it's really important for both people applying for disability benefits and then also service providers trying to help people to understand. And it kind of relates to the question of why there's so many denials at the initial stages. And so right here is the 5-step process that Social Security uses to determine whether or not someone meets their definition of being disabled. That first step is just considering whether or not they're earning above that set number. Again, this year is 1,470. So if someone's working and earning above that number, it doesn't matter what is going on with them, they won't be eligible. If they're under that number, they can move forward in the process. The second and third steps, we're not going to touch on too much. They're pretty technical, but they're oftentimes not too much of a problem. The fourth step, Social Security will determine whether or not the person applying is capable of performing any of the work they've done in the past. And then that final step, which is the real tough one, is Social Security will ask whether or not the person is able to do any work anywhere in the national economy. So that really means that people get denied because a judge or an adjudicator decides that even though there's no jobs available to them in Washington, and there's no kind of practical way they could work and earn a living, because it's theoretically possible somewhere in the United States national economy that they would be denied for that reason. And so my part of the presentation, and then I'll move it on to Hillary, just has some info about the 3 primary ways people apply for benefits, and then also how service providers like case managers can assist people throughout those processes. Really, there's a lot of different ways that people can apply for benefits. And though, the advice I give for someone wondering how they should do it really depends on their individual situation. The way I will discuss them will go in order of how simple it would be for a case manager to assist someone doing these processes to the more involved ways a case manager could assist somebody submit an application. And before we get started, regardless of what way somebody wants to apply, they're going to have to at some point collect all the same information. And it's quite a bit of information about themselves, their medical history, and their work history. Social Security publishes certain documents that are available on their website that are helpful in collecting that info for yourself, or helping someone collect that info about themselves. So I've linked those forms here. We'll make sure these slides are distributed because a lot of the slides I have for you guys are kind of designed to be referenced later. But here are the links to the forms. They're pretty well designed self-help forms. If you are helping someone, or you're just you yourself are applying and you're doing a phone appointment, consult these 2 forms up top. And then if you are trying to help somebody or advise them how to actually fill out an application themselves online, and we're going to talk about all these things, I would refer to this link down here, which has a information gathering sheet. And then just a tip at the bottom is that I think it is just super, super helpful for case managers or anyone helping anyone throughout this process. One of the most helpful things you can really do is just sit down with somebody and help them go through all the medical treatment they've received for whatever impairment they're dealing with. It seems like something that would be pretty simple, but sometimes people get a lot of medical attention from a lot of different providers, and it can be easy to forget or not remember. And especially if people are going through trauma or really severe medical stuff, it's hard to remember all the specific details. So a lot of my work really is sometimes just taking the time to meet with somebody, go through every single doctor they've had and record it in a fashion that it's easy to report to Social Security later on. So this is just taken from some of the forms. We won't spend too much time on it, but these are the types of info you would want to collect before you do an online application, or maybe after you've already scheduled a telephone application appointment and you're waiting for that to come. These are the sort of things you would want to collect info on. And again, the tip at the bottom is it's definitely a lot. It can feel overwhelming for clients going through this process or case managers helping people through the process. But at the end of the day, I mean, all you can do is try your best and give Social Security all the info that you have. It is also their job to collect info about the case as well independently. So just collect everything you can get, all the info, and order it in a way that it would be easy to communicate with Social Security. So here's the first of the 3 ways that clients can request appointments, or that you can help a client request an appointment. So this is just an online filing tool Social Security developed. I think it came out last summer or so. It's fairly new. But for this, you would just follow that link. This is particularly for people who are applying for SSI. So people who don't think they or don't have a lot of work history and who also have limited income and limited resources. So if that type of person wants to apply for SSI disability benefits, you would just use this tool. You would input their name, date of birth, and Social Security number. Just identifying information really. Important things would be mailing address and phone number as well, because the way this tool works is you just submit all that information. Social Security schedules you a telephone appointment to apply for disability benefits. And then that claimant or the client requesting the appointment, whoever's requesting the appointment, will receive a letter in the mail within 7 to 14 business days scheduling that appointment. They would also send that to the email as well if that person has an email and provides it. And if the client doesn't receive anything in the mail after 7-14 business days, I would just recommend following up with the Social Security office and seeing what's going on. I haven't used this tool a lot, but I have spoken to other people who have used it and it has worked for them. So I think that this is the most simple way if you don't have a lot of time to help a client through this process, or they don't have a lot of time to, they don't have the bandwidth right now to maybe go through the other channels. This is a really good way just to get your foot in the door or to help your client get started with an interview. Phone applications are another way. Essentially, this is just calling your local security office and requesting an appointment for an SSDI or SSI appointment, or both. Calling Social Security and scheduling these type of appointments can also just be really helpful in terms of the claimant can ask them, or you and the claimant can ask them which program do they qualify for and talk that through. In any event, it's a fairly easy process just to call and request an appointment, but the hard part is actually contacting them. And that's what we're going to talk about here. So for whatever reason, it's very difficult to find your local Social Security office's phone number. They have this online tool where you can enter your zip code, and it's supposed to give you the address and phone number for your local office. But if you do that, you enter the zip code and you will see the correct local office, but you will not see the correct phone number. They only provide a national number. So I've created this chart here that has all the local offices, at least in the immediate area, as well as their phone numbers. And these are the phone numbers to the direct office. And these are the ones that would be most useful to call if you wanted to get your client set up with an appointment to apply for disability. And then the final way, which is the way that is most involved for sure for case managers or claimants applying by themselves, but the way that I often do it myself, or when I help people, this is the way I do it, is doing an online application plus a follow-up with Social Security. Like Alex said earlier, Social Security really pushes the online application system. Frankly, I don't know why, but I do think it's easier for their workflow when people apply that way. So essentially you just go through you click this portal and you go through a very long application, and it is just an entire disability application. The pros of this is that you get a re-entry code, so you can kind of do it at your own pace. When you schedule a telephone appointment, either by calling or using that online filing tool, the client or the person applying needs to sit down for probably 2 hours on the phone with a Social Security representative, which can be kind of an onerous process and pretty draining, and especially for people dealing with mental health issues or other barriers impossible. And so doing it online is helpful because you get a re-entry code, you can log in and out of that application and go at your own pace. Just make sure you don't lose that code. I have done that one time and that was hard to get it back. And then the only cons of using the online application is that obviously the person applying would need access to a computer or someone with access to a computer. And that also using the online system requires you to make a My SSA account, basically just your personal account with Social Security. Setting up that account is very straightforward, but sometimes it requires a delay before you can file your application because you need to set up a My SSA account, then Social Security will mail you a code to activate that account. So all that's to say that there's the pros that you can kind of go in and out of the application and take your time, but there's also the cons that it does take a little while to actually submit the application if the My SSA account isn't already set up, and that it does rely on the claimant or having access to a computer. And then for online applications, it does require some follow-up if the claimant wants to apply for SSI. Technically, the online application portal only creates an SSDI application, and that's okay. If you're working with someone who just wants to apply for SSDI, then you just do the online application. If you're working with someone who wants to apply for SSDI and SSI, then you would just complete the application and then call your local Social Security office and ask them for an appointment to complete the SSI portion. That would not be the same as an actual telephone appointment. For a full application, they would really just use the info you already provided in the online application and review it with you essentially. And then if the client only wants to apply for SSI, you still can use the online application, you would follow the process up above, but just don't be surprised if that client doesn't have a lot of work history. They might be denied pretty quickly from the SSDI program, but that's okay, because a denial from the SSDI program doesn't mean a denial from the SSI program. If someone's applying for benefits through both programs, they would receive denials in both programs. And with that, I will send it to Hillary, and I'm sure we're gonna have a ton of questions, and we will touch on those after Hillary is finished up with her part. So I'm gonna stop sharing my screen.
All right, thanks, Tanner. While I'm getting my slides up, I did want to say I did answer a few questions in the chat. Some of them are going to be, the answers are going to be way too complicated to provide a succinct answer. And it also could be the fact that it may be very specific to each circumstance. So I tried to give a general overview. One thing I did want to touch on is that that came up in the chat, is kind of important or relevant to this conversation, is that, you know, this is for federal benefits program. We do have a state benefit program of ABD, age blind, disabled. If you have a pending SSI application, you can receive ABD benefits, the state cash benefits, which is now increased, it doubled basically. It's $417 now. With the caveat that if you do get approved for SSI, that has to be reimbursed to DSHS through your back pay. And there's some legislation actually right now being proposed that may prevent that from happening, which would be great, but just bear that in mind. That's another Tanner provided methods of, you know, online applications, et cetera, on how you as a case manager might be able to help a client through this process. Just getting an application in is an administrative thing, really. It's not really legal work. It might be helpful to know some of the definitions so you could better provide the information to Social Security, and we're going to give you some background on what might be helpful. But one other thing you could do if you absolutely don't even have time to do this, DSHS has an SSI facilitator program now, so that if you want to get your client on ABD, get some cash going right away, they have an SSI facilitator that will, all they do is submit an application, and all they care about is there still an application or appeal pending so that we can keep these benefits on, or do we need to turn the faucet off and stop the benefits? So I'm going to talk a little bit more about how you as a case manager, or whatever your specific role might be as a support for your clients, how you can help them through this process. A couple things to just keep in mind, knowing that we just talked about the type of applications. Why do you need to provide all of the medical records? You'll notice that the medical records or the applications will request the doctors they've been to, all of the providers related to any of the impairments that you claim on the application, and a time frame. And the reason is because they're going to request records. I'll go through in the next couple of slides about the exact steps of what this process looks like, but just know that it does help. It provides a historical picture for them. Maybe a client has tried to receive treatment and it hasn't been effective. All of that is relevant to showing why this person cannot work. And the last part I just wanted to tag on to his applications part is that there are some remarks that you can put in. There's a remarks section on the application. We have been told by one of my coworkers has been told that they don't even look at the remarks section. So take it with a grain of salt, but you can put some more information in there that might be relevant to your client's case specifically, especially if they're unhoused or homeless. SSA is supposed to flag a case for a claimant that is homeless. At the field office, I don't think that in effect they're doing anything about that, although their rules state that they're supposed to process it more in a priority setting for certain types of cases, and homelessness is one of them. I do know at the hearing level, they do process that. They put the scheduling in a more of a priority status if they know that the case has been flagged as homeless. So that's something you can ask for. And also, if you have helped them fill out the application, I just wanted to point out, I would put that in the remarks section, because otherwise Social Security might say, well, this person filled out this application just fine. And we've had that come up. So just know that if you do help, just disclose that whatever level you helped with. But what does the process even look like? I think this is helpful to know, because your clients are probably always going to ask, well, why hasn't it been done yet? I wish it would be faster. So right now you submit your application in whatever fashion, like Tanner outlined. You're submitting your application to the local field office, and I think he told you how to find that. I've been told, at least at Seattle Metro office, that they don't, if you submit stuff, it's taking them 60 days to even look at it, put it in a work track, assign it to somebody. So bear in mind that there's just a long log of processing applications. On top of that, then they have to review it for basic eligibility requirements, like if you're SSI, you've got those financial requirements. There's also citizenship requirements or immigration status requirements, which could be an entire other CLE. And so assuming they meet some of those basic things, then they transfer it to the department that's actually investigating the claim. That's the Division of Disability Determination Services, or DDS for short. They're part of DSHS. Every state contracts with every state has a contracted agency with the federal agency, which is SSA. They contract with someone in the state to do the actual investigation. This person is called a DDS adjudicator. Their job is to request the records. So as an applicant or a claimant, you don't have to provide the records. When you provide a list, the forms ask you to fill out. This is why, is because the DDS adjudicator is going to be requesting the records from the places that you said and the timeframes. And I err on the side of inclusive. So if my client's like, I don't know when I started, sometime in 2020, I'll go all the way back to January. I'll just say January 2020, get everything from then on. They might also, they will send questionnaires for sure. One is basically your activities of daily living. They'll send a work history questionnaire. They might also provide a third-party questionnaire. They give a section on the application where you can list a third party. That's more meant for like a caseworker or a family member or friend, someone who has observed how that person's impairments affect their life. The other big thing that might happen at DDS is a consultative exam might be scheduled. If there's not enough medical evidence, especially recent evidence within the last year, they're going to want to have an independent doctor, mental health, physical, vision, whatever's relevant to the claim, do a detailed evaluation, which then gets submitted to Social Security. A lot of issues surrounding this we could talk about, but for me, the important thing is helping the client make that appointment. If they miss too many, they'll just deny them because they said there's not enough evidence and they didn't comply with the requests. So make sure that the client is responding to everything DDS is sending out and that they're attending any scheduled appointments. I will also say that once it gets to DDS, a lot more will happen. When it's at the field office, your job might be contacting the field office. Why hasn't it moved? At DDS, you will get the client will get a notice with a name and a phone number of somebody you can call. So it's very important that you follow up with that person, because if they don't respond to a request, oftentimes my clients' addresses change frequently. They lose phone numbers, they lose phones, they don't have minutes. So it's important that you help them follow up with all of these steps. If they get denied, you can file a reconsideration at the field office again, and it goes back to DDS, basically a second shot at it. You get a new adjudicator, but they're looking at the claim from start to where your new application is. And then eventually you can, get denied again, hearing. I could go into more detail about all of these steps, but the important thing is to realize here is that appealing is different than just filing a new application. When you appeal, you are preserving your original filing date. And I'll explain why that's more important, but know that it could mean more money for your clients if they ultimately get approved. And the second thing is if you don't appeal a denial, it becomes a final decision. And when it's a final decision, that means that any new application, you're starting from here. Maybe I was disabled in 2017, but I didn't appeal, and now I'm starting again in 2023. Well, all that stuff that happened between 27 and 2023 really isn't important anymore, and I have to show a new or worsening condition, really, or something that was left out. Sometimes that's an easier hurdle because a lot of conditions deteriorate over time, but it does create a level of complexity. So if your client still wants to follow through with the claim, I would encourage appealing versus just filing a new application. So how can you help? There's a lot of things that case managers can do to help support a client through a claim. Obviously, Tanner already explained how you can help them even get an application in. That can be a big hurdle because our little organization, we have a lot of need, and we're trying to triage and take the cases that have the most barriers and all of these things. So if you can at least get an application in, that would be a huge help for your clients. The other thing is establishing a reliable mailing address. Social Security gives notices and communicates primarily through mail, especially DDS. They're going to send a mail when it's there that if they've tried to call you and they can't reach you, they'll send you a 10-day notice. You have to contact me within 10 days or I might close your claim out. That might not always be the case. They give you some extensions, et cetera, but they are going to send all the notices by mail. They'll send your questionnaires by mail. If you don't respond, then you're not participating in the claim and they could deny you. Managing the claim and deadlines. So like I said, making appointments. If you know that a CE has been scheduled for February 1st, you might need to do all the things to help your client, to remind them, to help get them there. Social Security is supposed to provide transportation, but that's not really reliable. So there's all of that to consider. I think I missed a slide. Yeah. So the other thing to consider in helping your clients through the case, I kind of put in the other slide, I didn't mention it here, but this process is going to take a long time. In my experience right now, it's probably before you get a decision on an initial claim, estimate anywhere 9 to 12 months, but it could be, there's a lot of complicating factors there. If you need to appeal, even longer. So if you notice that a client has a gap in medical treatment, that's a common reason why claims get denied. If the client is willing to go, they just haven't had the support or the referrals or whatever needed, it's not too late to establish it when you get an application in, because you're seeing how long it's going to take. If obviously it's their body, it's their choice. But I tell my clients, if you are interested in it, that's going to become medical evidence. And perhaps you could build a relationship with a medical provider that will be a support for your claim. They could provide some letters of support, which I'll explain in a second. So they could even do a detailed assessment. So that could be something that you could do, as recognizing a need there and filling a gap if that's something the client is interested in. There's also some post-application evidence you can help gather. In particular, there are some other stuff, like if you know your client had an IEP, or there's some other agency that may have records that somehow didn't get disclosed, you might want to support that. When you're communicating with DDS, if you're not an authorized rep, you're going to have the client present, but have them, if there's ask what medical records did they request? Maybe there's a gap. Maybe they didn't request all of the medical records, or they didn't get the records even if they requested. So you can help kind of gather that material if you need. And I'll go over the letters of support in the next slide, but also referring to us, I find it so helpful when the community partners, or, if there's a caseworker on the case, they are such a vital part of establishing a line of communication with the clients. Most of my clients are unhoused, and so they lose their phones. They don't have a stable mailing address, and I just have to wait until they contact me. But if I know there's a caseworker and there's something pressing on their case, I can reach out to the caseworker, who usually has more of a regular communication. So that's vital. And just know when you refer to us, the types of cases we've kind of gone over, especially when there's a lot of barriers to even getting an application submitted, you can reach out to us and we could find a way to help you do that. But especially if they've gotten denied at some level, that might be at the stage where having an attorney jump in the case might be more helpful to get that application approved. And so supporting materials that you can provide, this is really important. Hit or miss whether Social Security is going to rely on it. I will say once it gets to the hearing level, these things can become even more important. But there's different types of letters of support. Obviously, it's going to look different if you're asking the medical provider to provide a letter, because they can go into diagnoses and medical opinions. But if you're a caseworker, there's a lot of things that you can write in a letter of support that's vital to supporting the actual legal part of the claim, because you're observing, especially not just the things that your client tells you, because that's kind of subjective, but what do you observe? What's your personal knowledge? And you probably have a lot on your client's claims. Like, I'm just thinking of an example, like, there might be a client that has PTSD and has had regular outbursts that you've witnessed or observed, or you've talked about the recurring thoughts or the insomnia that goes with it. That might support the claim of what his testimony is, but you're a third party that has no interest and you're saying the same things. The interactions they've had with other people, you probably observe that regularly. If they've had memory problems, do they have trouble making appointments because of their impairments, whether it's mental health or otherwise? Those are all things that you observe and you can write about. The one caveat that I put there is because unfortunately in this context with Social Security, it's considered a legal decision. If you say this person cannot work because of their disability, or this person is disabled and they cannot work, that's kind of like, a lot of people might think that's common sense. Of course they can't work. Look at what they're doing. But the problem is under Social Security rules, that's actually something that administrative law judge is supposed to decide under the law. So I wouldn't say that, but you can say how their impairments affect their daily life, the barriers they overcome, kind of more like the effect of it, not the cause. You know, I'm seeing that this person, you know, has trouble keeping up with their hygiene, or they can't make appointments, whatever the actual barriers are or the effect of those impairments, I think is key and really helpful when a caseworker can identify those. And you might know about some specialized assessments or help gather those as well. I know we're running out of time, so I'm going to speed through a couple of these, but protective filing date, I do want you to understand, get an application in as soon as you can, but it's really the earliest date that you have your written intent to file, verbal intent to file. So if you call Social Security and ask for an appointment, that's your protective filing date when you ask. If you have done the protective filing tool online, that's your protective date, regardless of when your application even gets submitted. So that's why, if you're working on these things, try to do that. Call Social Security or do the tool. Protective filing date is important because it's the earliest date that the claimant could receive benefits if they're actually approved. So let's say you have applied January 1st, they get approved in December 31st. So that's 12 months that Social Security should have been paying them if they later approve them. And that's all back pay. There's a lot of complicating rules on how they actually, back pay might be reduced for various reasons, like if they had in-kind support, they lived with somebody and didn't pay rent. But overall, that's something that, that back pay can be a huge support for somebody, especially getting established if they're going to get housing eventually. So just remember, the goal is to contact Social Security as soon as possible. And the other part about onset date kind of relates to that too. This is when you're going to say when that person became disabled so that they could not work. I just wanted to highlight this because if you're applying for SSDI, so again, disability insurance, that's a program you're considered insured under based on your work credits. If your work credits expire, you're no longer insured and you don't have access to that program. So it's important to keep in mind, if you have somebody that does have work history, and Tanner talked about the 10 years out of the last 5 years out of the last 10 years, those are 20 work credits. You can earn up to 4 credits per year, but they eventually expire if you don't apply. It's when your disability is within 5 years of that is kind of the rule of thumb. That when you stop working and your disability is your onset date of that disability. So really the goal here is that your alleged onset date, when you could no longer work, is sometime before your date last insured or when you were last insured and your credits were still valid. Complicated there. So if you do have an issue where you're not quite sure, you might want some guidance there on what you're alleging. You can change the onset date, that can be amended, but just know that if you have somebody that does have work history, it's important not to wait too long to apply because you want to make sure that you have access to those benefits. This is stuff you can all read yourself, but following through, helping your client through the process, making sure they stay attached to the process. If they do miss an appeal deadline, you can later open it for good cause within a year pretty easily. After that, it's a little more hard, but staying on top of those timelines is really important. And I think having a caseworker or somebody, an advocate on the side of the claimant is, I think it really helps improve their level of success in the application stage. So I think we may have a couple minutes for questions, but I know I want to give Peter enough time too. So if there's any, Tanner, did you notice a major question we should attach, or otherwise we could go back to, we can answer them in email if we don't have time.
I didn't see too many I didn't get to, or that you didn't get to when I was going. One question we have here is, does having financial resources put in a special needs trust exempt it from being counted as a resource? And the answer to that one is yes. Hillary, do you want to add anything?
Yeah, I guess it kind of, yes, potentially. Like it depends on how the trust has been set up. They did change the rules in 2017 so that it could be self-settled too. It didn't just have to be a third party. So special needs trust should exempt that. And it has to be designed in a specific way, and the language has to be appropriate. So it can be sticky, but in the general scheme, yes, you can.
I'm not seeing anything else in the chat. So if you guys have more questions, feel free to email us or put them in there. But I think Peter, you wanna get started?
You know, there was one quick question on a similar topic that I wanted to elevate really quick. We were asked, does that 1470 in the income limit include TANF income, or if it's just restricted to earned income from a job?
Needs-based income or needs-based, yeah, any sort of needs-based payments would be exempt from SGA income calculation.
Thank you.
And I think that's probably a good segue into my section, which is going to be, I titled it Overpayments, but it's a little bit more about basically anything that happens after somebody receives Social Security benefits. So I'm going to get my slides on the screen here in a quick second.
While Peter is working to get his slides up, I just wanted to remind folks that I'm going to drop the post survey link in again. This is really, really helpful for us because we would be happy to talk with and invite benefits law folks back for another session. We are doing a ton of work around public benefits. It includes a series of trainings, but then also wanting to connect with folks that are doing this work to learn about a lot of the issues that you're seeing, trying to look, you all are doing such good work on the individual level, how to pull up and look at some of the system issues that the coalition can help. It was, mentioned that having to repay the back payment of ABD when you get approved for SSI. Coalition is right now actively working on that legislation. We have an action alert to talk to legislators about it. So I'm going to throw both of those things back in there. And Peter, I'm going to hand it back to you.
Thank you so much. Can everybody see my slides all right?
No.
No, okay. Let's see here. How about now?
You're good.
All right.
And
Perfect.
you can, yeah.
All right, so my name is Peter Greiser. I'm the Director of Legal Services at BLC, and so I'm going to talk a little bit about overpayments and stuff that occurs after you get on Social Security benefits. We call that post-eligibility issues. Potential overpayment eligibility issues. The way that I like to think about these issues is that Social Security is making an eligibility decision for every month that they pay out your benefits. Your benefits are a monthly benefit, and so each month they're making a determination that you're eligible when they pay you. And so if and when Social Security makes a determination that, oh, they paid you benefits in the past that they now realize you weren't eligible for, or they believe you weren't eligible for, that's what's creating an overpayment. They're saying, we paid you your SSI benefits for the year of 2022. We now realize that we believe you're not eligible for 2022, so we're going to ask for all of that money back. And when they make a determination moving forward about your eligibility, that can result in reductions of benefits or terminations of benefits. So all of that stuff kind of happens based on them making a determination about your eligibility on at a monthly level. I split these issues up into things that can happen to folks who are either SSDI or SSI recipients, and then issues that are kind of purely SSI based. The first issue that can happen to anybody who's receiving a disability related benefit is what's called a CDR, or continuing disability review. Everybody who is determined to be disabled by the Social Security Administration is put into a bucket in a different kind of category based on how likely Social Security believes they are to improve to a point where they're no longer disabled. And so that can be, they can have a CDR, can occur as regularly as I think every 18 months. That's pretty uncommon. And it can go out as far as once every 7 years or so. In my experience, the main driver in how often somebody gets a continuing disability review is really, at the end of the day, how much work Social Security has or how motivated they are to do these reviews. I've had clients who told me that they had never had a review and they had been receiving SSI for 10 years. So at the end of the day, the important information is that CDRs happen, continuing disability reviews happen, and the essential kind of the thing to know is what occurs is that Social Security is just making sure, is looking at updated medical records, and they're making sure that there is not evidence of improvement. It's a different disability standard than somebody getting on benefits. And statistically, it's pretty likely that your continuing disability review is going to be approved unless there is medical evidence of significant improvement in your impairments. And I'll get into more details on that later. The other thing that affects both SSDI and SSI beneficiaries and their eligibility is earned income, wages from work. There are different standards, and I'll get into this in more detail later. SSDI is that substantial gainful activity SGA standard, and there's some pretty complex rules about when somebody is eligible while they're working on SSDI benefits. SSI has a slightly simpler standard, which is any sort of earned income is going to reduce your monthly SSI at a 2-to-1 level. For every $2 you earn, your SSI will be reduced by $1. And that's theoretically 2 months after you earn it. They do a delay to allow for reporting of your wages. So it's not simply you're eligible or you're not eligible. At least in theory, it is a sliding scale based on how much you're earning, with the caveat that if you are working at a level that's pretty high, closer to full time, that sort of stuff can turn into a flag for Social Security to do a disability review and to look into whether or not your disabilities have quote unquote improved to the point where you can work at a full-time level. So there's the substantial gainful activity standard is a little nebulous and can slide into a world where, oh, we're doing now a continuing disability review because your work is close enough to substantial gainful activity to where we think you might be able to perform it at that level. And then for some brief SSI overpayment issues that are unique to SSI, unearned income. We touched a little bit on that with the inheritance question or special needs, getting any sort of money into a special needs trust. Settlements are also considered unearned income. Gifts, child support, all that stuff can be considered unearned income for Social Security for SSI purposes. And unearned income reduces your monthly benefit at a 1-to-1 rate. So it is a harsher standard than the 2-to-1 for earned income. Your living situation also affects your SSI, as we've noted. There's a married couple SSI amount that's less than the combination of two individuals who receive SSI, so that your marital status will affect it. If you have a child, that will affect your living situation, your SSI benefits. And I'll get into something later called in-kind support and maintenance, which is Social Security's version of reducing your SSI based on what they believe is in-kind income or somebody giving you support through food or shelter that is not cash based. Living outside the United States for more than 30 days makes you ineligible for SSI. So that is something that I always flag for my clients who do travel or who have family in another country, if they're going to stay outside the United States for more than 30 calendar days. And then we'll talk a little bit about resources as well in detail. Social Security has a $2,000 resource limit for SSI, and that is the combined value of all of your resources that they count. We'll get into a little bit about what they count versus what they don't count, but that $2,000 limit is cut and dry. And so if you have more than $2,000 on the first of the month, you are not eligible for any SSI in that month. So the whole 914 would be considered to be overpaid for that month. In a little bit more detail, again, there are two kinds of financial rules for SSI: income and resources. Income is money that you get in the month that you receive it. And then resources is, for example, money that you've held on to past the month of receipt, and then other sorts of things that are held on to that hold value, so to speak. Like I mentioned before, earned income is going to reduce your SSI at a 2-to-1 rate, unearned at a 1-to-1 rate. And then we have this issue of in-kind support and maintenance, which is the value of food or shelter. Social Security, because SSI is considered a quote unquote welfare program or a low income program, they are concerned, or they are focused on whether or not you are paying your fair share, quote unquote, for your food and shelter. So I see a lot of overpayments wherein somebody lives with a family member and Social Security asks the family member, how much are you charging rent for this person? And how much would you charge rent for somebody who isn't a family member? And if those numbers are different, the difference is essentially an in-kind support and maintenance income, meaning that if you are charging someone less than fair market value for their housing, then you're giving them the value of that housing, and they count that as income for Social Security purposes. It gets kind of complex, it gets kind of fact specific, and I don't really want to go into too much detail because there's so much to cover here and I want to get to questions, but they are focused on that concept of fair market value, and that gets really tough if somebody's living in Seattle city limits, or really, frankly, anywhere in King County at this point, because the monthly benefit is so low. It results in people, family members, for example, giving people discounts on their housing, and Social Security turning around and reducing their benefits even more. There is a key exception here, which is federally subsidized housing, your Section 8s. People who are in the Section 8 program, they're not going to receive an in-kind support maintenance reduction because of that. That's the one way that I know of where people can get affordable housing and not have their SSI reduced in Seattle city limits. Are folks who are receiving Section 8 and have significantly subsidized rental agreements. And then to get into the $2,000 resource limit, again, that is a determination that's theoretically made on the first of every month. And so if on the first of the month, your bank account says $2,500, you're not eligible for SSI. And so there are some key exceptions to note, though, which is one, if you own property and a home on that property and you live in that home, Social Security will not count it. However, if you don't live in that home, if it's property that you just own somewhere else, that is a resource for you. That is something that Social Security determines that you could theoretically sell and use that money instead of SSI. And the other key exception is a car that you use for your primary mode of transportation. That's one car. If somebody owns two cars, for example, they will discount the value of the more expensive car. So if you have a car that's worth $5,000 and you have a car that's worth $1,000, they will count the value of the $5,000 car, or they will discount the value of the $5,000 car, and they will count the $1,000 car against you, meaning that your bank account has to be less than $1,000 every month. Because again, that value, the $2,000 resource limit stacks up. It's $2,000, all of your countable resources. Generally speaking, personal goods, household items are not countable resources. You can have a television, that's not going to count. You can have two televisions, that's not going to count. You can have things, you can have a computer, that sort of stuff. Social Security is not going to count in most cases, pretty unlikely, because those things have value beyond retention. They have use, they have utility. You're not just holding on to those things for the pure purpose of the value of them to sell them one day later. And so they're not going to count as a resource. If you or your client, if your client gets an overpayment notice, usually these things are pretty time sensitive. Social Security is going to issue out a decision, and that decision is going to relate to their eligibility at a monthly level, depending on what the thing is. We've determined that you make $500 in earned income, so your SSI is going down. We've determined that you own this property that you don't live in, it's not even in the United States, and we've determined that it's valued at $10,000, so you're not eligible for SSI. If you appeal that determination in and of itself within 10 days, you get what they call Goldberg v. Kelly rights. And what that is a right to the continuing SSI benefit while the decision is being made, until at least they make an initial determination on appeal about the status of this determination, whether it's your income, whether it's your resources, what have you. The thing to note about Goldberg v. Kelly rights and asserting those rights is if you are receiving the benefits while you're appealing, and the ultimate result of the appeal is that the determination was ultimately correct, all of those benefits that you've been receiving while you were appealing could be an additional overpayment. Now, again, you're making that, everybody has to make that calculation for themselves about, how necessary this money is. In my experience, folks need the money and they'll worry about the overpayment later. But again, that's something to note with your clients, that if you are pursuing continued benefits after Social Security has made an initial determination, any sort of benefit that you receive could be an additional overpayment. That 10-day deadline, and I include 5 days for mailing. So what you should note is that with deadlines for Social Security appeals, they use the date of the notice that they've printed out on the top. It's usually the top right corner has the date of the notice. They use that date for calculations, but they will assume that you receive it 5 days after that date. So you have a 5 days from mailing from that date. So just add 5 days on to the date of the notice, and then whatever the deadline is. So 10 days for Goldberg v. Kelly rights, and then 60 days for appealing what they call a request for reconsideration. A request for reconsideration is an appeal of the determination, essentially saying the determination is incorrect. Social Security, you've determined that I own a property that I do not own. Social Security, you're saying I'm making money that I'm not making. That is a request for reconsideration. You have 60 days to appeal that. If you appeal after 60 days, you can do that, but you're going to have to also request good cause for late filing, explain to Social Security why the appeal was late. I'm homeless. I didn't receive the mail. I didn't know that you had made this determination because I didn't receive the mail until I called Social Security. Or I was in the hospital for 3 months and I got home and I saw this letter. Those are examples of good cause. And Social Security generally will grant good cause in those circumstances and will allow for a late filed request for reconsideration. The request for waiver is a slightly different appeal. It does not have a strict deadline. It's good to get appeals in quickly. I'll get into that in more detail, but you don't have to file that within 60 days, strictly speaking. And then the last way to respond to an overpayment is what they call a request for change in overpayment recovery rate, or a payment plan, which is simply not contesting the existence of the overpayment, but rather challenging the amount that Social Security takes out of your Social Security check, or agreeing to pay Social Security to avoid wage garnishment or tax return garnishment, which are two administrative procedures the agency can take. Relatively rare, but theoretically Social Security can garnish wages to repay an overpayment, or could take a tax return to repay an overpayment. I'm going to get into the appeals a little bit more in detail now. The request for reconsideration, like I mentioned, is if you disagree with the reason for the overpayment, or you disagree with the amount of the overpayment, you're challenging the underlying causes or determinations behind the overpayment. You can file what's called the SSA 561, and you can find it online. Social Security has a web page that's all of their publicly available forms, and the request for reconsideration form is one of them. It's, I think, it's technically 4 pages. 2 of the pages are instructions on how to fill it out, and then the remaining 2 pages are actually duplicates. So it's really 1 page to fill out. You can do it relatively quickly. It doesn't require a lot of detail. Usually what I write when I'm helping someone fill one out is, I'm disagreeing with the determination that XYZ, whatever it is with Social Security, because whatever my reasons are, and then I send that off to Social Security. Pretty quick, pretty easy to fill out. that does have the 60-day deadline, or if you're going to file it beyond 60 days, some sort of written statement of good cause for your late filing. And then the other kind of appeal is what they call a request for waiver. That's form SSA 632. And this is essentially, you are not appealing the overpayment itself. You're not appealing the existence of it. You're saying, yes, this overpayment does indeed exist at some level, but it's not my fault that I was overpaid. And fault is determined. It has an agency definition that's not what you and I would consider fault. It's a pretty strict standard. And the other thing that you have to prove to win a waiver is that it would be unfair to collect this overpayment from you. If someone is an SSI beneficiary, currently they're still receiving SSI benefits. It is one reason it would be unfair to collect against you is because you can't afford to pay it. And someone who is an SSI beneficiary is basically de facto unable to pay their overpayments because they are considered by the government to be low income by definition, by the fact that they receive these benefits. They're a low income person. Unlike the reconsideration, the waiver can be filed at any time. I usually, in a lot of cases, I'll file both together. And Social Security will do the reconsideration first. And if the reconsideration is ultimately denied, then they will pursue the waiver. So that's usually what I recommend folks doing. It's a longer form. It's, I think, 15 pages. It's only 8 pages if you are a current SSI beneficiary, because you don't have to fill out the financial disclosures because Social Security already has a lot of that information because you're receiving SSI. But it's still a longer form than the reconsideration. So that's one thing to note. And because it can be filed at any time, I don't have one hard and fast practice when it comes to filing those, with the exception of if someone's already filed a reconsideration and it's been denied, then I'll get that waiver filed as soon as possible. The other thing to note with overpayments is that depending on the program of your Social Security benefits, there are different rules about how much Social Security can withhold from your monthly benefits. So if you're an SSI beneficiary, by statute, Social Security can only withhold 10% of your monthly benefits to recover an overpayment. So $914 a month is the maximum SSI benefit in 2023. So $91.40 is the most that Social Security can take from a current SSI beneficiary from their SSI benefits. That rule does not exist for SSDI or retirement beneficiaries. They can take up to 100%. Usually that's what they take. They'll just not pay you monthly benefits. And so when somebody's benefits are stopped and they are an SSDI beneficiary, there is an additional question of whether or not Social Security has determined that they are no longer eligible for benefits, or if they're still eligible for benefits, but they're taking the entire amount out to repay an old overpayment. So that's something that a lot of my clients don't necessarily know, and we have to get in contact with Social Security to find out. And then the final course of action when it comes to an overpayment is this payment plan. This is something that I usually save for last if my client wants to challenge things. There's also a circumstance wherein Social Security has already made a determination on the reconsideration and on the waiver. And even if you want to appeal those through the appellate process up to a judge, after they've made that initial determination, they can take money out. They can't take money out of your check if you have an appeal in before an initial determination has been made. But once that initial determination on appeal has been made, they can start to take money out. So if I have a client who's waiting for a hearing with a judge, I'll file a payment plan just to protect as much of their benefits as possible. Or if I have a client who just doesn't want to deal with the appellate process, or doesn't really, we've had a discussion and we don't believe that they are likely to succeed, or they don't want to deal with it, we'll file a payment plan at that point as well. The rule of thumb to note with a payment plan is Social Security is very likely to approve a plan that repays an overpayment within 36 months. That's pretty unrealistic in most cases, at least that I've seen. So usually I'm requesting a payment plan that's lower than that. And at that point, it's Social Security's discretion. So the payment plan form looks very similar to the waiver forms financial disclosures. And so what it does is it asks you to list all of your income, and it asks you to list all of your monthly expenses. And you simply do the arithmetic of here's my income minus my expenses, and here's the money I have left over. And so I use that as my guidepost for a proposed payment plan rate. If my client has $50 left over at the end of every month, I'm going to suggest something less than $50, maybe 25, maybe 20. The minimum that Social Security will accept in a payment plan is $10 a month. So I usually err on the lower end, and if it gets denied, then we submit another one, or we have a conversation with Social Security about proposing a different rate. But I tend to err on the side of lower and wait for Social Security to deny, and then I come back with something slightly higher. And then I think this is the last thing before I can get into some questions, but this is a little bit more detail on the continuing disability review, which I mentioned earlier. Every person who receives disability-based benefits is going to be reviewed by Social Security at some point to ensure that they're still eligible. It's a different disability standard. Like I mentioned before, it's really about, do we have medical evidence of improvement? This, of course, can feel a lot like the application process all over again. It can be very traumatic. It can be very stress provoking, but it's important to just respond quickly and to return all of the forms as completed as possible. And like Hillary and Tanner have mentioned before, making sure that if they're receiving assistance in filling these forms out, that they note that, so that Social Security is aware that this is not necessarily somebody who is all of a sudden able to fill out all of these forms. They're getting assistance still. They may still have attentional deficits. They may still have cognitive deficits. The first level of continuing disability review is really simply just a medical record compilation that exists. There's not a lot of involvement from the client. The client may not even really participate at all, other than to let Social Security know where they're still receiving medical care from. And their benefits are going to continue throughout that process. It's just simply, we are looking at the medical records again. We're making sure you're still disabled. If they're denied at that first level, then benefits may stop. They have 10 days to invoke their Goldberg v. Kelly rights and choose to receive their conditional benefits while the appeals are ongoing. And the appeals can go on for a couple of years. And so it's important to note that, hey, if you're choosing to receive these conditional benefits, they are indeed conditional, that you are still eligible for benefits. If Social Security ultimately determines that you were ineligible this entire time, they're going to ask for that money back. And so that's going to be another overpayment. I will say, in my experience, that particular overpayment is pretty easy to waive. That particular overpayment, the administration usually will consider the person not to be at fault, as long as the person can demonstrate that they truly believe that they continue to be disabled and that they were engaging in the process in good faith. They were showing up to any sort of examinations that the administration scheduled. They showed up to any hearings that the administration scheduled. They filled out all the forms. As long as they're doing that, that's a really good show of good faith. That's a really good show that you're not at fault in creating this overpayment because you believed you were disabled. And so those overpayments, I do have some success getting waived. So I do let my clients know that, yeah, it can be an overpayment, but if you're, really following up in this process, if you're really engaging in this process, even if it is an overpayment, you're probably going to get it waived. And so that's something that I note with folks. Are there any questions? I think we have 10 minutes or so.
There are definitely some in the chat, and then it looks like we've got a hand up as well. Oh, maybe not.
Okay, I'll start from the bottom of the chat. The question is, if they're determining eligibility monthly, why are overpayments happening? That's a great question. Certainly in some cases, it's because they're not actually making that determination monthly, for whatever reason, whether that's a workflow issue or whether, that may be a workflow issue. At that level, that is a waivable overpayment, right? You're saying Social Security, it's not my fault that this overpayment occurred. You didn't make the determination until way later. In most cases, what I'm seeing is Social Security is at least claiming that the thing that caused the overpayment was not immediately reported to them. So the overpayments that I see more often than not are, oh, it's 2023 and we found out that you owned a property in XYZ country that's worth $5,000 for the last 5 years and you never told us. And so then the question is, well, did they tell them? You know, what actually occurred there? But in most cases, what I'm seeing is Social Security is claiming that the precipitating event, the catalyst, was not actually reported to them. And whether or not that's true becomes a whole other, that's the litigation in and of itself. I see a question about, can resources over $2,000 be protected through an ABLE account? The answer to that is yes. ABLE accounts can be excludable resources. It gets kind of fact specific, but it's similar to the special needs trust situation. It's a yes and answer. Yes, and you have to fit some regulatory requirements, but generally speaking, yes, an ABLE account is a good way to protect resources.
I see a question from Steve Vaughn with his hand up.
Yeah, thank you so much for taking my questions. My question is that the SSI receiver died on the 6th of January, and SSA asked for the overpayment the rest of the month. I mean the days, like, you know, from the 7th to the 31st. So is that normal? Is that?
Yeah, I don't know if I've ever actually seen that before in my work. I would have to do some research and get back to you on that. My gut tells me that sounds right, but I would want to do some research before I gave you a final answer on that. So you have my email. Send that to me, please, in an email, and I'll do some research and get back to you on a final answer.
Thank you so much.
Mm-hmm. Thank you for that question. That's a good one.
Peter, I saw a question here about Social Security. Are they informing people when their time to work will coming to an end? I think maybe they mean trial work period or extended period of eligibility. How are they letting them work over? You know, can you explain kind of the notices that might come in a work setting?
Yeah, totally. Yeah, so you will see, at least theoretically, Social Security should send notices when, for example, and I'm just going to use the SSDI example. I didn't mention this in too much detail because I find it gets a little complex, but it is an issue that is a lot of my work right now, which is SSDI beneficiaries who are working. When you're an SSDI beneficiary and you're working, the only standard is that SGA, the substantial gainful activity standard, which is the monthly countable income, which I think is it was $1,350 last year and it's 14 something this year. That amount, so when you start working, you get 9 months of a trial work period, which means that it's 9 non-consecutive months in which you can work as much as you want, as much as you can, and you'll still get your Social Security benefits. So the threshold that triggers a trial work period is actually lower than substantial gainful activity. So for most cases, you're working, you're triggering your trial work period, and everybody thinks everything's fine. You're receiving your benefits, and Social Security isn't really worried about things, and things seem hunky-dory. Theoretically, at the end of the 9th month, Social Security should send you a notice that says, hey, your trial work period is done. Keep reporting your earnings to us, and you have now entered what's called the extended period of eligibility. The extended period of eligibility is 36 consecutive months, wherein if you work under substantial gainful activity in that month, you are eligible for benefits. But if you work over substantial gainful activity in that month, you are not eligible for benefits. And so you theoretically can go up and down, up and down, up and down, up and down for 36 months. And that the effectiveness, the efficacy of that particular regime really depends on how active both the claimant and Social Security are in communicating with each other about, oh, I've worked this much, I'm going to send in my pay stubs, and oh, you know, Social Security sent me a check for this month, but I worked over substantial gainful activity, so I should probably let them know. It's very up and down, and overpayments exist quite a bit, even with that stuff, even when clients are really active with Social Security. And then where we get a problem is at the end of the 36 months, the 37th month and ongoing, you are always on kind of a razor's edge at that point, because you do not get automatically re-entitled if you go over substantial gainful activity. So if in the 37th month you work substantial gainful activity, you are now unentitled from benefits entirely. And so a huge source of big $50,000, $60,000 overpayments is somebody worked over substantial gainful activity. For whatever reason, Social Security didn't find out until 3 years later. And so now the overpayment is 3 years worth of benefits, and Social Security is saying, you're not eligible for benefits because you worked after your extended period of eligibility and you're no longer disabled. So that is a real complex world, and that's why I hesitated to get into it in too much detail. But essentially, theoretically, to go back and try to answer that question succinctly, theoretically, Social Security is communicating with folks through notices. The question is whether or not that's very rarely highlighted in the notice. It's usually buried under a couple of pages. And that also means that Social Security actually knows that this work is going on and that something hasn't happened in a miscommunication between the claimant and the Social Security about the nature of the work or the amount of the work. And I see, oh yeah, please.
Okay, so the person is separated and cut off SSI from being when they were married.
William, we're having a hard time hearing you, both I think volume and cutting in and out. Are you able to put anything into the chat?
Yeah, I'll put it in the chat.
Thank you.
Thank you. And I can answer this lot. I see a question in the chat, you know, isn't that about or around 19 hours a week of work? Yeah, the answer is that this is the substantial gainful activity threshold is a national standard because Social Security is a federal administration. They're going to do federal national standards, and they do not consider the fact that the wages are very regional. So this is a big issue in big cities, and particularly Seattle right now, which is someone who is working at a substantial gainful activity level is not even necessarily making enough money to survive, frankly. So this is something that I would love to see there be some sort of legislative change on. I'm not, you know, particularly optimistic about that, but it is something that I think activists should really focus on.
Thanks, William. We'll have Peter reply to this last one, and then I think that'll be the last one, and we'll collect any others that got popped into the chat.
Yeah, so the thing to note for SSI, so the question is, if someone is separated and is cut off SSI, how should they reapply? And so the first thing to note is that SSI has what they call a 12-month suspension period. And so if you are suspended from benefits, meaning if Social Security determines that you're not eligible for benefits, you have 12 months to kind of correct whatever issue Social Security has with your eligibility and inform them. And then theoretically, you don't even need to reapply because you're actually suspended, you're not terminated. Now, if that suspension has gone on for 12 consecutive months, then you are terminated. So if, for example, I'm going to use a different example other than the separation, but I'll just do like you had $5,000 in your bank account. If you spend $3,000 out of that bank account and you spend it on things that Social Security accepts as acceptable resources to purchase, and you let them know within a month or two, you can get your benefits turned back on without having to reapply. But if there's 12 months of you having that $5,000 in your bank account, then you're terminated. And the only way to reapply is to do what Tanner and Hillary discussed in their presentation, which is to contact Social Security, probably over the telephone. And I think that's the most efficient way right now. And get in line for a telephone application for SSI, and they'll make a totally new determination about your disability and your eligibility moving forward. But if this is something that's less than 12 months, you should call Social Security, inform them that the thing that made you ineligible is no longer a current status. And theoretically, if you're within 12 months, Social Security should be able to fix that if you have some sort of documentary proof of that.
Great. Thank you, Peter, so much. Thank you to the entire Benefits Law Center team. Alex, Hui, Hillary, Tanner, Peter, and Hannah, who did an amazing job, I think, of promoting this training. Thanks for everybody for hanging in there with us. This was a ton of wonderful information, and we will be sure to share out the full recording, slides, resources, contact information, all in a blog post. If you registered for this training or had a colleague that registered but wasn't actually able to attend, you'll get that notice for sure. Hugely helpful. Thank you so much. I'm going to throw a couple more links into the chat for you just because TANF came up quite a bit. And so I wanted to make sure folks know that next month on Wednesday, February 15th, we're doing a training on the working family tax credit. We're going to do a whole nother series on HEN-ABD, TANF Work First, Medicare, Medicaid in the spring. Our training and development page has all those links. You can register now, reserve your spot. And then I just want to invite everybody to join the coalition. We held monthly membership meetings. Those are available to the public. We do a lot of information around the legislative session. That came up quite a bit today. We try to share key information. It's just good networking, getting to know other folks. So thanks so much for your time. Again, Benefits Law Center, this was wonderful. Thank you. Really appreciate your time. We will follow up with you after the fact. Everybody have a lovely rest of your day. Be well and take care. Thanks, folks.